At the end of all the evidence, the coroner is required to make findings of fact based on the evidence before reaching a conclusion. In a coroner's court, the test is on the balance of probabilities, so whether something is more likely to have happened than not. The coroner does not have to be certain or satisfied beyond reasonable doubt, like in a criminal court. If there has been healthcare provided to the person prior to the death, the coroner will give consideration to whether any acts or omissions in that care were causative of the death. That doesn't mean, though, that the coroner is attributing fault or blame. The coroner is concerned with determining these matters as facts. They then turn to the 5 questions, and the answers to these are recorded on a record of inquest. The coroner will record the deceased's name, a medical cause of death, and a summary of how they came by their death. In the simpler cases, this is a couple of sentences, but in the more complex cases, this can be several paragraphs. A simple example might include, Mr. X was crossing the road when he was hit by a car on the 1st of January. He suffered fatal injuries and died at the scene. Next, the coroner needs to record their final conclusion as to the death, and this used to be called a verdict. Coroners are encouraged to use what we call a short-form conclusion where possible, and this is a list of words or phrases which reflect the circumstances of the death. In the example of the man hit by the car, it could be road traffic collision, or another option would be accident. A large number of inquests will conclude with natural causes, even if there is a criticism of care or treatment, for example, in the answer to how the deceased came by their death. Other options are drug or alcohol related, or suicide. For suicide, the law has changed, and this no longer needs to be proved beyond reasonable doubt. It's now the same as all other conclusions, and the coroner needs only to be satisfied on the balance of probabilities that there was an intentional act with the intention of ending their life. If the coroner doesn't think that one of the short-form conclusions is appropriate, they can use a narrative, which is essentially a few sentences explaining the conclusion. This needs to be brief, neutral, and clear. An example might be, Miss Y died by hanging whilst under the influence of alcohol. Her intention at the time cannot be determined. The final part of the record of inquest covers the details needed for registration purposes and for a final death certificate.